Good morning, everyone.
Good morning.
Thank you all so much for being here with us today. Just kind of waiting for folks to start filtering in as we're just hitting 11 a.m. But I just wanted to say thank you for being here with us today. We are absolutely thrilled because registration for today's event is off the charts, and that warrants a huge thank you and shout out to our awesome client services manager, Lisa Snyder. So thank you, Lisa, for getting everyone registered and keeping us organized. We saw tons of familiar names on the attendee list, but for those of you who are guests of our clients and who may not know us, this is Doug Kahn, and I'm Annalise Krauthamel. We are members of the Trust, Estate, and Wealth Preservation section here at Unruh Turner Burke & Freeze, and the Elder Law Solutions section as well. And we're just excited that you're all here and really looking forward to spending the next hour and a half together. A couple of housekeeping items before we get started. There is going to be a question and answer window. You should see that down at the bottom of your screen. So any questions that you have throughout the program, please just enter them into that window. We will try to answer as many as we possibly can at the end, but as I said, we do have a lot of participants, attendees, so that might be difficult. We will kind of circle back with you after the fact if we're not able to get to your question. Your questions are not visible to the other participants, so feel free to ask anything that you would like, and don't worry about it being what you might perceive to be a stupid question. There is no such thing. And there will also be a brief survey at the end of the program after we disconnect. So we ask that you please complete the survey and give us your honest, unfiltered feedback. The responses are anonymous, and your feedback really helps us to provide quality programs in the future. So with all of that being said, I'm just looking at people still filtering in, so we'll give it maybe just a second here before we start digging in. I'll go ahead and get us moving and just talk about the general disclaimer. We would be remiss, we would be bad lawyers if we did not provide our little introductory disclaimer. Today's presentation is educational only. We'll be covering a general overview of laws and legal concepts related to elder law planning, but it is not legal advice. And that's because each person's individual circumstances are so unique and they just vary greatly. So we invite you to reach out following today's presentation and schedule an appointment to discuss your particular situation so that we can talk about really formulating a strategy that is tailored specifically to your needs. So it looks like a lot of our attendees have filtered in. We do have limited time, so I'll just jump right in. I think that when embarking on an educational journey, such as the one we are about to begin, I think it's really valuable, and I think Doug agrees, to go into it knowing what we plan to get out of it and identify what our goals are. So that begs the questions, why are we here and what are we going to achieve? And so our first big goal is to really understand what is elder law and how and why it differs from estate planning. So I think that most of you on this call are likely familiar, at least a bit, with traditional estate planning and to have familiarity with documents such as wills and revocable trusts. And you may have heard about elder law planning, but just don't really know exactly what it is and how it's different than having a will or revocable trust. So we think that a great way to really think about that differentiation between the two is that traditional estate planning is geared towards making sure that your assets are distributed to your loved ones and beneficiaries in accordance with your wishes when you pass away. And elder law planning is really geared towards ensuring that there are assets to be distributed at that time, and ensuring that there are assets left for you to leave to your children, to your grandchildren, other beneficiaries, is accomplished by acting now, proactively, to protect them from the exorbitant cost of long-term nursing home care before you actually need that level of care. So today, I think it's safe to say that what we're going to achieve really is an introduction. We want to introduce you to the concepts and planning opportunities that are available to you in order to protect your family home, vacation home, and other assets from, frankly, the insanely high and rapidly rising cost of nursing home spending And we'll do that today by learning about the rules for qualifying to have Medicaid pay for that long-term care, and how to qualify for Medicaid without having to spend down all of your assets, and doing that through the use of a very special, sophisticated type of trust planning known as a Medicaid Asset Protection Trust. So the MAPT, as we like to call it, we love our acronyms, is a phenomenal planning technique. And today you're going to learn about how a MAPT is created and funded, how a MAPT is managed, what the benefits of MAPT planning are, and some common, often in most cases, unfounded concerns that people express about MAPT planning. So that is our roadmap for the rest of our time together today. So we'll start out, how much does it cost to stay in a nursing home? I think it's really important to understand what you are confronting. So every year, Pennsylvania releases the data related to the average cost of nursing home care in the state. For 2023, that is $423.11 a day, which equates to almost $13,000 a month. So this is the average. In our experience, the cost of care in our particular region of the state frequently substantially exceeds this average. And as you can see, a monthly expenditure of this magnitude can really be crippling to the total value of an estate. And this scary, honestly, ugly truth is what drives lots of our clients to come to us to talk about elder law planning and how to protect and preserve assets from this ever-rising cost. And so where do your assets go? If you need long-term nursing care and you haven't done any pre-planning, they go straight to the nursing home, and very quickly. And so assets are being spent down at a clip of $12,000 to $19,000 per month. That's up to $228,000 per year. That's for a single person. Now, multiply that by 2. If you're looking at a married couple, that you're looking at over $450,000 a year. And so this is a really, I think when you look at it this way, and a lot of clients haven't kind of considered it in this framework, it's shocking. It's like really astounding. And if you look at an estate that's say valued around $1 million for a single person, that would be entirely depleted in just over 4 years. For a married couple with an estate of $1.5 million approximately, you're looking at complete total expenditure depletion in just over 3 years. And so we're talking about this really high, astronomically expensive long-term care cost. And I'm sure a lot of folks think, surely there must be something that can be done, some help that's available for seniors who need nursing home care. And there is. It is Medicaid's program for long-term care, but you have to qualify for that assistance. It's not something that's just immediately available to all seniors that need care. And kind of a preliminary discussion and a topic that's important to understand is the difference between Medicaid and Medicare. And so we often hear clients using these terms interchangeably, and the concepts, I think, are confused. Medicaid is a federally funded, state-run program that pays for the nursing home expenses of those who no longer have sufficient assets of their own. So if you are in a nursing home and you run out of money, Medicaid will kick in to pay for your care. Medicare is a health insurance program that pays for things like doctor visits, medication, hospitalization, etc. Qualifying for and having Medicare coverage does not mean that Medicaid will pay for your care. So without doing any prior planning, if you need nursing home care, you will have to privately pay for that care until you have almost entirely expended all of your assets in a single person scenario. And we'll get into sort of that in more detail here, the single person versus married couple situation. But once all of your assets are gone, that is when Medicaid will kick in and pay the tab for your care. Also, really what we're going to discuss mostly today is related to that financial qualification, but also it's worth mentioning that as a preliminary matter, there is also this non-financial qualification requirement as well. So we're not going to spend a tremendous amount of time covering this, But it's important to know that an individual has to require a high level of medical care on a daily basis in order to medically qualify for Medicaid in Pennsylvania. So a person applying for Medicaid must be what's known as nursing facility clinically eligible, or NFCE in the Medicaid lingo. And this typically means that the person needs so much assistance with the 5 activities of daily living, which are personal hygiene and grooming, dressing, using the restroom, transferring or ambulating. Also, you just think in terms of mobility, getting out of bed, et cetera, and eating. And needs so much assistance with those activities that he or she has to live in a nursing home facility rather than remaining at home or living in a community that provides a lower level of care, such as assisted living. So there is no bright line rule for medical eligibility that covers every single situation, but the formal determination of whether someone has reached the skilled level of nursing care is made only after an assessment is completed by the local area agency on aging. So important takeaway from this: Medicaid will not pay for assisted living. Medicaid only pays for nursing home level of care, whether that's in a facility or at home. This is kind of beyond the scope of today's presentation, but there are programs that do provide for in-home care, which Medicaid will pay if all of the requirements are met, and they're generally more stringent than kind of the requirements that we're going to talk about today for nursing home facility care. So once someone has been determined to be medically eligible for Medicaid, how do they qualify financially? That's going to be our focus here. And the short answer really is by having just about nothing. And so when we're thinking about this financial eligibility and qualification, the focus is really on whether assets are countable or exempt. And so Medicaid sees a countable asset as being available to pay for a person's care, and therefore that it must be spent down before Medicaid will kick in. And so what are some examples of countable assets? It's really most of the assets that you own, with minor exemptions and exceptions. So checkings accounts, savings accounts, CDs, investment accounts, stocks, mutual funds, etc. The person that needs the care, that includes also their retirement accounts, IRAs, 401ks, and we'll get into that in a little bit more detail. So what is somebody allowed to keep if they are applying for Medicaid? A single individual. So there's this differentiation between a single person and a married couple, and kind of different rules that apply to each scenario. So an individual person applying for Medicaid is allowed to keep a car, and they can keep their house, but this is a little bit misleading. So you're allowed to keep your home if you make a statement saying that you plan to return home, which that's not difficult to do. However, even if you retain that home, there is this estate recovery program. And this is a surprise to a lot of people to learn that this exists. And so what that looks like is while Medicaid is paying for that person's care while they're in the nursing home, they're keeping a running tab. So you've retained the home, but Medicaid is keeping track of everything that they've paid for your care. And when you pass away, your estate will have to pay back everything that Medicaid has paid for your care. So all of those Medicaid expenditures are going to be paid back out of the estate assets, including your home. And so only any amount that exceeds the repayment of that Medicaid expenditure will transfer to your beneficiaries. And so you may feel sort of as though you're keeping the house, but in reality, that's not actually the outcome. You're also allowed as an individual to keep $2,400 worth of assets, and a paltry $45 a month of your income you are allowed to keep for incidentals. Any other income has to be paid to the care facility. So for example, if you're receiving $2,045 per month of Social Security, $2,000 would go to the care facility, and you would be able to keep $45. And as I said, it's a little bit different dealing with married couples. And so if the person applying for Medicaid has a spouse who does not need nursing home care, we call that spouse the community spouse. That's what they're referred to as. And the spouse who does need the care is known as the institutionalized spouse. So there are different rules that apply when there is a community spouse. The community spouse is allowed to keep some of the countable assets. And the idea of these rules is that you want to keep the community spouse from becoming impoverished due to the institutionalized spouse's need for care. So the community spouse is allowed to keep a car. They're allowed to keep the house, but this is subject to certain limitations. So for 2023, the value of that home cannot exceed $688,000. If it does, you are allowed to petition to be able to keep the home, but it's possible that that could be rejected. You could be denied, and you would then have to sell the home, purchase another with a value less than $688,000, and the overage would have to be spent on the care for the institutionalized spouse. So the community spouse is allowed to keep their own IRA, no matter what the value is. So that's I always like to point that out. That is an exempt asset, but the institutionalized spouse's IRA is not exempt. That is available to pay for their care. So the community spouse can keep half of the remaining assets, or $148,620, whichever is less. And so I stress that less. And this is an important concept to understand. So for example, if there's a $500,000 joint account, you would have to spend that down to $148,620. Then that institutionalized spouse could apply for Medicaid. So if it's less than that, so if you say have $150,000 in a joint account, you would have to spend that down to $75,000. So that's how that calculation works. Also, the institutionalized spouse is able to retain, again, that very small amount, $2,400. And the thing to remember about this is everything that we're talking about here is kind of worst case scenario. This is really meant to highlight what happens if you didn't do any additional and advanced planning and one spouse needs care. This just kind of gives you that frame of reference for that scenario. And let's take a look. We have a little chart. And so this reiterates, and I think in a kind of nice to view, easily well-organized way, some of the information that we just discussed. One of the things to note that we haven't talked about is this monthly needs allowance amount. This is the amount of the overall income that the spouse at home can retain. And so out of the total of all pension, Social Security, and other income of the institutionalized spouse, the community spouse can keep only $3,715. Any income of the institutionalized spouse over that amount must be paid to the care facility before Medicaid would kick in and start paying the bill. And to clarify, the spouse at home gets to keep all of his or her income. And so that's kind of the background. This is really what we're dealing with when we talk about the sky-high cost of nursing home care. This is it. I think you've gotten a flavor for Medicaid qualification, just some of the basics, and frankly, how pretty minuscule the asset limitations are. And I think that having this background is crucial because it really gives you this accurate backdrop from which to absorb the rest of the program. The rest of the program really focuses on the solution. How are we protecting your home and assets from these high costs and not ending up in this situation where we're looking at this worst case scenario? And with that, and without further ado, I will turn it over to Doug.
Thanks, Annalise. That was great. As Annalise said, it's important for you to get that backdrop and a good understanding of the worst case scenario so that you can see that there are solutions available that we'll talk about that can help protect assets in excess of what those standards would provide if you do nothing. So we'll talk a little bit about why someone would actually want to do this Medicaid planning and why qualifying for Medicaid sooner will be helpful. So we've talked about the community spouse. So obviously If you are potentially in need of care, you're going to want to make sure that your spouse at home has assets that are sufficient to get them through the balance of their lifetime. So, and our overarching goal for married couples is to make sure that the spouse at home will have assets that are sufficient to take care of themselves, despite the fact that their spouse has now moved into a care facility. Many of our clients want to preserve the family home for children and grandchildren. So central to planning opportunities that we'll work with clients on, we can take steps to move the family home and other real estate into position where it would be protected from the long-term care spending. You can also preserve financial assets by qualifying for Medicaid sooner. These assets can transfer to the children and grandchildren of the individuals who are ultimately in need of the care. So you can see here a Medicaid qualification, having Medicaid paying for your long-term care can help to preserve these assets and have them passed down to the children and family members, and also be available for the community spouse even after you've moved into a nursing home. What kind of planning can be done now to help protect and preserve assets for your spouse and children? Gifting. Gifting is the primary planning opportunity that we have, and that gifting takes many different forms. So you'll hear us talk about gifting throughout this program. We'll highlight gifting to the Medicaid Asset Protection Trust, and the reason for that will become apparent as we talk through that, because you do have an opportunity to gift directly to children and other beneficiaries and start what is a 5-year ineligibility and look back period. So it's important to know that outright gifting is an available option. It just happens to be a lesser option when it's compared to gifting to the Medicaid Asset Protection Trust. So we'll go through why the Medicaid Asset Protection Trust is the superior destination for your gifts. But either gift, just taking a step back, either gift outright to an individual or into the Medicaid Asset Protection Trust will carry a 5-year ineligibility period for Medicaid qualification. So a real key component here is knowing that you have to do this planning well in advance of needing the care. So most of our clients who are doing this planning are in a position where they feel comfortable that they can get through the next 5 years, either through personal pay or good health without needing long-term care. And we'll talk a little bit more about that. So the Medicaid Asset Protection Trust, as I had mentioned, is a key tool for us as we're doing Medicaid asset protection planning. So we'll go through creating the Medicaid Asset Protection Trust, how we establish it initially, and then we'll go through the funding of the Medicaid Asset Protection Trust, and then some of the management issues as far as trustee positions and their responsibilities on a go-forward basis. What is a Medicaid Asset Protection Trust and how is it managed? First of all, very important to know that the Medicaid Asset Protection Trust is an irrevocable trust. So once you create this trust document, it becomes a freestanding legal entity. It will have its own tax identification number, and it will not be considered an asset that is a part of your financial world. So once you've created this entity, it's separate and distinct from you as the creator of that trust. And because it's irrevocable, it means that you no longer have the ability to reach in and change the terms of that document. So once you set those terms in motion, you have to feel comfortable and secure that what you've done is what you want on a go-forward basis, because you no longer have the ability to modify those terms from that point forward. The irrevocable trust provides a place for you to make gifts. So rather than making these outright gifts to children and family members, you would literally make the gifts to this Medicaid Asset Protection Trust, where the assets would be held presumably for the balance of your lifetime. You would name a trustee, which would be a person, typically a family member, who would be responsible for managing the assets that are held in the trust. So even though you will give up ownership and control and you'll no longer be the person in charge, you get to pick the person who would be best suited to manage those assets for the balance of your lifetime. Again, as I mentioned, most commonly, it will be a child or other trusted loved one who would be in charge of handling those trustee responsibilities. We'll typically tailor the trust to each family situation. So this is definitely not a one-size-fits-all situation. We'll sit down with clients, go through what their intentions are, what they would like to have happen with the assets after they've put them into the trust, and then we'll basically write this trust document for your particular circumstances to make sure that they're managed properly for the balance of your lifetime, and then ultimately that they pass to the beneficiaries that you want to receive those assets and in the way that you want them to be received. Importantly, assets that are transferred to the Medicaid Asset Protection Trust start a 5-year ineligibility period. So our goal here is to move assets now while you're healthy and not in need of that long-term care, so that we start the 5-year clock ticking. The sooner we start the clock ticking, the more likely that you'll get through that 5-year waiting period before you would have to apply for medical assistance. And if you move those assets into the trust and are through the 5-year waiting period, then everything that you had put into the trust will be protected from the long-term care spending, and you will be that much closer to qualifying for Medicaid, because the assets in the trust will not be countable when you're applying for medical assistance. And that's the key here. Moving the assets early, starting the clock ticking on the 5-year waiting period, and moving closer to Medicaid qualification. Each separate gift that you make to the trust will carry its own separate 5-year waiting period. The example would be if you transfer your home today into the trust, you'll have 5 years from today until that home is protected. If you choose to transfer an additional amount of money, let's say $100,000 a year from now, the $100,000 gift that you make 1 year from now will be protected 5 years from that date, okay? The new gift made a year from now will not impact the home transfer that you made today. So they're separate and distinct from one another, but each one will carry its own 5-year waiting period. So I usually advise clients as best as possible to transfer assets upfront and early so that we have a clean, concise window where we know 5 years from this general time frame, these assets will be protected. But these situations do arise where maybe new money is available and a new transfer is made at a later date. And you can certainly do that. You just have to know that the transfer of the new money into the trust will have its own 5-year waiting period. So what assets can be transferred to the Medicaid Asset Protection Trust? We have a lot, really wide berth in transferring assets to the trust. So this trust is, again, its own legal entity. I like to think of it as almost like a small business entity. A lot of you have heard of people creating LLCs or small businesses to hold real estate or other financial assets. the Medicaid Asset Protection Trust is very much like that. We have someone in charge as the trustee, and they have the ability to not only invest in these different assets, but they can hold the assets that you've transferred there. So we can go down this row and you'll see it virtually covers the gambit of your financial world with a few exceptions. So we'll see here real estate, so your primary home or even an investment home, stocks, bonds, mutual funds, business interests, non-qualified annuities, cash, and even life insurance policies. So the transfer is pretty straightforward. You would have to create a deed for the home or go to the financial institution and work with a financial advisor or agent at that institution to have them move assets out of your name and into that irrevocable trust. Certain things cannot be held by the Medicaid Asset Protection Trust. Pretty short list, but more or less it's retirement assets. So primarily IRAs and 401ks, also 403bs and pension profit sharing plans, but those are assets that have to be owned by an individual during the individual's lifetime who had initially established those. So the only way for you to move your IRA assets into the Medicaid Asset Protection Trust would be if you withdrew all of the funds from the IRA and moved those funds into the Medicaid Asset Protection Trust. Now, that will take a lot of decision making together with your tax and financial advisor, because the traditional IRAs and 401ks are tax deferred, which means that as you take the money out, you will incur income tax on what you've taken out. So in order to take the money and move it into the irrevocable trust for Medicaid asset protection, you have to pay the tax first. And if you're doing that with larger amounts of money, you'll obviously then be triggering higher tax rates, because that will be pushing your tax bracket higher. So as I say, you really have to take your time reviewing those issues with your tax advisor and your financial advisor, because that would definitely be against what their typical advice would be for you as your manager managing your assets going forward. It's just that in the face of the exigency of possible long-term care spending, you might decide that the penalty associated with paying that tax earlier and maybe at slightly higher rates is a better result than waiting and possibly having to spend 100% of those dollars on long-term care. Those are things that we can't really answer, and no one probably will have the crystal ball and the ability to know exactly what the right answer is. But I do want you to know that there is somewhat of a conundrum there in dealing with the IRAs and 401ks. Of course, your impulse might be to move those dollars quickly into the irrevocable trust for Medicaid purposes, but then you'd get this tax bill and might be sorry, especially if you talk to your financial and tax advisors afterwards.
Quickly, Doug, real estate. What if it's encumbered? What if there's a mortgage? I have a lot of clients in that situation that have that question.
Yeah, it's a great question. So if you own a home and there is a mortgage against the property, you would not be able to transfer ownership of that real estate while the mortgage is against the property. I suppose you could try to get permission from the lending entity to transfer ownership, but they're not likely to grant it because their agreement is with you as an individual, and you're the one that they had qualified to be able to pay that mortgage during the balance of your lifetime. And you have some income that's coming in, whether it's from your pension, employment, or Social Security. Whereas the trust as an entity will not have any kind of track record of income production, and therefore will not be viewed as a good risk for lending assets. So I think the long story short there is you'd probably have to pay your mortgage off first before you transfer the property into the Medicaid Asset Protection Trust.
Right.
So important component of this planning is selection of the trustee of the Medicaid Asset Protection Trust. Okay, so let's go through some of these issues and who the most common trustees would be. So you're selecting someone that you feel strongly will be basically your arm as it relates to handling the decision making of the assets inside of the Medicaid Asset Protection Trust. Most of our clients, I'd say 95%, select one of their children to act as the trustee. Okay, but it can be multiple children. It could be a friend or a, even a more distant relative if that's preferred. And we do have that happen. Once the assets are in the trust, it's nice because now we have an individual who we trust making decisions, and the likelihood is, and our goal for this person is for them to treat the assets as though they are yours, even though they technically are not owned by you as an individual. So we want them to invest the way you would have invested, hold assets that you would want to hold. We want them to manage real estate the way you would have managed it had you been the owner. So a lot of our clients just expect the trustee to be someone who is going to do the things that they would have done had they continued to own those assets themselves. The grantor, basically the creator of the trust, and their spouse are disqualified from acting as the trustee. So we need someone who would be separate from the grantor to act in that capacity. We highly recommend the appointment of something we refer to as a disinterested distribution trustee. It's almost it's not an actual, it says required. It's not an actual requirement that you have it. It's just that we virtually require all of our clients to have it, because having a separate outside trustee, so this would be someone other than your child who is the primary interested trustee. You can either appoint someone to be the disinterested trustee or require that your child appoint someone at a later date whenever they decide that a distribution from the trust is necessary. The reason for having this disinterested trustee is to provide maximum asset protection for the assets that are inside of the trust. Not only are we trying to protect the assets from this long-term care spending, but one of the biggest components of this Medicaid Asset Protection Trust is that it also protects and preserves the assets from the things that might happen in your children's or your beneficiaries' personal lives after you've transferred the assets to the trust. One of our primary objectives is to protect the grantor from losing these assets during their remaining lifetime. So again, we'll talk about this more, but we don't want outright gifts to the beneficiaries, because once you put these assets in the individual's names, they become susceptible to divorce, creditors, lawsuits. Assets inside of the Medicaid Asset Protection Trust, especially a Medicaid Asset Protection Trust that has a disinterested distribution trustee, will be protected from all of those personal life issues of the future beneficiaries. We get to have these assets in this safe place for the balance of your lifetime and managed by a person that you trust to make all of the right decisions.
I get this question a lot when we're talking about trustees. What if you end up being unhappy with the person that's been appointed as the disinterested trustee, or maybe your child is not doing what needs to be done, has gone off the rails in some respect?
I mean,
How do you deal with that? People are
are
often afraid of that outcome and possibility.
yeah, I mean, these are great questions. And this is it's a topic that we go over with every client who is considering doing this planning. And if there is a stumbling block for individuals as they're thinking about doing this planning or not, it's the giving up control and the worry that the person or people that you're putting in charge might not do what they're supposed to do, and they might even act against your best interest at some point. So we look for solutions for these problems and these concerns. The solution for this particular issue is something we refer to as the trust protector. So we like to add a provision to every one of these Medicaid asset protection trusts, which says that you are naming an individual or an entity to fill this role of trust protector. That trust protector needs to be an independent third party. So it's not another one of your kids, typically not a closely related family member. It could be a friend. It could be our office. We act in that capacity frequently. It could be a financial advisor's office. It could be an accountant's office, another advisor's office. So it just has to be somebody who's arm's length, someone who you could reach out to and isn't closely related to the activities of the trust on a regular basis and is not a future beneficiary of the trust. One of the benefits of the trust protector is you can list out all of their powers and authorities, including the ability to remove a trustee and to appoint a successor trustee. So in this scenario, where we have a rogue trustee not acting properly, or maybe just not being responsive, because that happens too, in situations where we've been involved in the past, a trustee just falls off the grid, and we're like, what do we do now? Well, we've got the trust protector, so now we have a way to fill this vacancy and appoint a new trustee in that scenario. The trust protector is great because it does not require court approval, because you have thoughtfully provided the trust protector with this list of powers in advance. They can act based on those authorizations without having to go to court to ask a judge if it's okay or not. So they can act quickly and less expensively. And they can take care of these worries that you have related to the removal and replacement of trustees and filling vacancies. But they can also update the trust if there is a change in the law or a change in family circumstance. These things happen all the time. I mean, we create these documents today, and they're irrevocable trusts. So we want them to be irrevocable because that's how we start the clock ticking on this 5-year ineligibility period. But we don't want them to not be adaptable. So that's what we're doing here, is creating adaptability so things can be updated and modified over time. So if there's a change in the law and we need to update or adapt, we call the trust protector, and the trust protector can come in, update the document to make it run as efficiently for tax purposes or asset protection purposes as we need it to. It can also update for family circumstances. So things change over time, and we all know that. Personal lives change, and things that we know today about a family member may be completely different 5 years from now. So if we need to adapt the language of the trust document to account for these family circumstances, again, the trust protector will be there for us to call upon and make those changes, again, more quickly and easily. It's important to note that this trust protector appointment is what we refer to as a non-fiduciary role. That means that the trust protector will not have an everyday involvement and oversight of the trust activity. So it's very innocuous. They're going to be written into the document. They're not going to insert themselves into the everyday management of the trust or the trust assets. They'll be there if you need them. And you basically just need to get in touch with the trust protector when it becomes apparent that they're needed, and then they'll be able to step in and help out. But they're not going to be looking over the trustee's shoulders. They're not going to be watching out on a regular basis for the activities of the trust. And you don't really want that in a position like this. We're just putting it there so that we can fend off situations that might arise. But we don't want a trust protector who has these everyday responsibilities, because among other things, if you made the trust protector a fiduciary underneath of the document, they would actually have to charge a regular and continuous fee, because there's a lot of liability risk to a fiduciary who has to be watching out vigilantly. And so even though something may not be happening, it's just the time expenditure of having to watch out for it, and also the possibility that something could go wrong on their watch. So the trust protector would certainly want to be paid for taking on that risk and responsibility. So having them act as a non-fiduciary alleviates a good deal of that worry, and also would take away the need for that regular and continuous fee structure.
I'm glad you said that, Doug. I have a lot of clients who have that question. What is the compensation for the trust protector in this capacity? So yeah, the preemptively address that.
The trust protector likely, especially if it's a third party, and I can only speak to the situations where we act, we charge when we're called upon. And we just basically charge the hourly rate that we would have as attorneys when we're helping clients do things on a regular basis. So it's not an annual fee or an ongoing expense. It's an as called upon fee for the work that we do. And I think, I mean, that's fair. And what else could you ask for, really? I mean, I guess you could ask for it to be completely free, but we probably wouldn't want to do it in that circumstance.
All right. So I think that's great information: creating the trust, funding the trust, managing the trust assets, who's that trustee. So now let's talk about some of the benefits of this Medicaid Asset Protection Trust.
So we've alluded to some of these things as we've been talking, but I think it's important to reiterate the items that we've already talked about, and obviously talk about a couple of new ones as well. So main benefit, main thrust of doing this planning is to create the Medicaid eligibility and protect assets. So 5 years and a day after each gift to the Medicaid trust, the gifted assets will be 100% protected from nursing home spending. So that's our primary goal. And of course, a primary benefit of the trust planning, where we're transferring our home, financial assets, and other interests into the trust so that we can get those things protected. The assets inside of the trust will be protected during the grantor's lifetime, not only from Medicaid and asset spending for long-term care, but also from things that could even happen in the grantor's personal life. So I know these are kind of far off items, but I'm just sort of highlighting just how extensive these protections are. If the grantor were to ever get into problems in their personal life, let's say they get into a car accident and hadn't paid their car insurance and they get sued, the assets in the Medicaid Asset Protection Trust are going to be protected from those things. So we've got protection from liability risks of the grantor, and we've got protection from the liability risks happening in the beneficiary's personal lives. So again, we're putting these assets into the trust. We're not putting them in the kids or the beneficiary's personal names, because if we did, those assets would be susceptible to divorce, creditors, and lawsuits that are impacting the children and beneficiaries. Transferring the assets into the irrevocable trust is far better than these direct gifts, because we're insulating the assets inside of the trust from all of those personal life worries. We want these assets to be there for the kids, ultimately, in most cases, but we also want them to continue to be there and available for the benefit of the grantor for the rest of his or her lifetime. So we need to insulate the assets inside of the trust from all of those kinds of things. Just want to touch on one item here, is the myth of gifting your home to your children for the dollar. That is considered a gift of the entire amount, okay? And it causes Medicaid ineligibility. So it doesn't matter that you've quote unquote gifted or sold the house to the child for $1. Medicaid, when you're applying, will view that as though it was a gift causing a 5-year ineligibility period. Okay, so I get that question all the time. So we wanted to put that in there to make sure that you're aware of it as well. So, if you're hearing someone, in your neighborhood talking about it, or a family friend who says, oh, well, you can just sell your house to your child for $1. The answer to that is that's a 5-year ineligibility period. Okay, so you're not really accomplishing anything except for putting the house in your child's name and making it susceptible to divorce, lawsuits, and creditors of that individual child. When we're putting the assets in the trust, it's really important to understand that the assets will be pooled in this entity with the trustee in charge, and each of the individual children. So most of our clients have multiple children. They're looking to have these assets ultimately shared by multiple beneficiaries. We're just not putting everybody in charge of these assets while you're alive. So we get to pick the trusted child, in most cases, who's in charge of managing the assets. And this curbs the possibility of each individual gift recipient spending the portion of the assets that they've been gifted individually during your lifetime. So if you take $1 million and you spread it $200,000 to each of your 5 children, by the time we get down the road, if you need nursing home care, I guarantee 2, 3, or more of those children will have spent some portion of the $200,000 that you had gifted to them. Some of them might have spent all of it. And if you need to get some portion of those assets back, now the poor child that you've gifted money to, who was good and didn't spend any of your money, will have to give all of it back, whereas the ones that had spent it are going to be like, I don't have it, it's gone. So the good kids get penalized in those situations. Whereas in this case, with the Medicaid Asset Protection Trust, you get to put the prudent manager of the assets in charge. You get to make sure that those assets can't be freely spent down by the individuals. The person who is managing the assets as the trustee will have the ability to make distributions out of the trust, but it will be at their discretion. Okay, so they'll have the ability to make distributions as they think appropriate. And we'll talk more about that. Assets that are inside of the trust will avoid probate. So it's important to know that once you put these assets into the trust, the beneficiaries of that trust will take hold. So we'll talk a lot during the planning process about the beneficiaries of the trust after you've passed away. So this trust will act very similar to the way you would think of a will or a revocable trust operating after you pass away. It will serve to say who inherits the remainder of the trust assets after you die. Because the assets have been placed into the trust during your lifetime, you obviously won't own them when you die individually, and therefore they won't be a part of your estate. And as a result, those assets are going to avoid probate. Probate is the court administrative process where an executor has to administer your estate and make sure that all of the rules are followed, and there's some expense associated with that. And by moving the assets into the Medicaid Asset Protection Trust, you're going to avoid, in a lot of cases, the red tape of probate and also the expense associated with it.
Right. Now, probate fees different than tax. That's sometimes something that folks get confused, but that's another benefit of this planning is the potential avoidance of inheritance tax also. So
yeah,
walk us through that.
Yeah, the probate fees through the court are relatively low as compared to other states. Many states charge a high probate fee, and that's tantamount to their tax. And so avoiding probate in those states is paramount on the planning side. Whereas in Pennsylvania, the probate fees through the court are a little bit lower than most states. And the reason for that is that Pennsylvania has a inheritance tax, and that inheritance tax is separate and distinct from the probate fee. They're totally unrelated. Pennsylvania's inheritance tax applies to transfers of your assets at the time you pass away, and the tax rate is dependent on who you're leaving those assets to. So this chart says it all, but we can go down quickly with you what those tax rates are. Transfers to spouse, 0%. Transfers to children and grandchildren, 4.5%. Transfers to parents, 4.5%. To siblings, 12%. To nieces and nephews, 15%. Aunts and uncles, 15%. Friends, 15%. And charities is 0. Okay. So by transferring significant money or assets to the Medicaid Asset Protection Trust during your lifetime, we have the potential for fairly significant inheritance tax savings. So you'll see again with this chart, and we're taking the most common scenario where you're leaving assets to your children or grandchildren, and there being a 4.5% tax rate. We're seeing the savings on the amount that you've transferred to the Medicaid Asset Protection Trust. So for $250,000 transferred to the trust, the potential savings is $11,250. For $1,500,000 at 4.5%, we're saving $67,500 of Pennsylvania inheritance tax. So we can see here that might not be our primary goal for doing this planning, which is again protecting all of the money from long-term care spending. But if we're doing this planning and we're avoiding probate and we're potentially avoiding inheritance tax, you can see here that the savings from those two things alone are likely to well exceed any cost that you'll have up front for doing the planning. So we get quite a few nice additional benefits as we're going through the planning process that you wouldn't even think about, because you're probably having this narrow focused idea, like let's protect the money from nursing home spending. But when we're doing the planning, this is why you usually hire us to do this kind of planning, is that we have our eye across the board. We're looking for other ways to save you money and make this worthwhile, because we know that there's a possibility that you'll never need long-term care. And so we want you to feel like you've done this planning and you've gotten a lot out of it, despite the fact that maybe you never actually end up having to do it for the Medicaid nursing home issue, but you got $67,500 of Pennsylvania inheritance tax savings, or
Does that make you happy?
makes me, I'm ecstatic.
I love seeing that.
And then you got probate avoidance, so you've made everything go faster and easier and less expensively for the kids. So we're always looking for additional benefits to provide to you through the planning, above and beyond just this very singular Medicaid issue.
Awesome. Thank you, Doug.
Sure.
I love going through these benefits of the planning with clients. You kind of see like this light bulb go off,
Yeah.
the eyes light up, and it's very exciting. I love this planning. It's so helpful to our clients and to their children, grandchildren. But sometimes when we're having these discussions, there are these concerns that clients have, and these are the more common of those. So we're going to talk about them and why in a lot of instances, they are concerns. It's not that they're not legitimate, but there are solutions to those concerns that really give you that peace of mind. So
Yes.
we'll talk about protecting if you transfer real estate into the Medicaid Asset Protection Trust. I have lots of clients who say, well, wait a minute, if one of my children, my child is acting as trustee and they kick me out of the house, that's sometimes a concern. Not that they actually think that the child's going to do that, but as Doug mentioned, this idea of giving up control can be daunting and scary. And so there is the ability to protect your right to live in the home. What if you need long-term care before you've gotten to the end of that 5-year period? What happens? Was this all for nothing? Can you access the assets that are inside of the trust after you've transferred them? What if while your real estate, the home, your primary residence or a vacation home is inside of that trust and it needs to be sold? Can that happen if you need to purchase a new home? Clients express sort of the concern, well, we're just going to be stuck in this house forever. Now that it's in the trust, we have no option. So we're going to talk about these concerns.
Okay, thanks. Yes, there's always concerns, and that's what we're looking to do as well, alleviate these concerns. So we're always working the problem. We're looking at these issues that clients bring up, and we're looking for ways to make you feel more comfortable and confident as you're doing the planning, to know that these worries and concerns are being met through good planning. Okay, so here's one of them, probably the first question: can the trustee kick me out of my home before I want to leave? So we want to make sure that if you transfer your home to the Medicaid Asset Protection Trust, that you can stay there for the rest of your lifetime, okay? If that's what you want. Obviously, you can move out if that's what you'd like as well. And we'll talk about what would happen if you want to sell the home. But if you want to stay there, we will protect your ability to reside there, usually in one of two ways. One is through a life estate agreement. The life estate agreement will basically say that you get to live there and continue to reside in the property. No one can force you to leave so long as you continue to make all of the payments associated with taking care of the property. So you basically have retained a sliver of ownership of the property. And that sliver of ownership is the right to reside there and pay for the expenses related to the property. Now, along with that right to reside there and that sliver of ownership, you also get a result that we'll talk about in more detail, but that ownership interest causes the property value to be includable and taxable in your estate. So we've talked about that inheritance tax savings. If you retain the life estate, the property will be includable and taxable in your estate, and the inheritance tax will have to be paid on the value of that property through your estate when you pass away. That doesn't mean it'll be available for nursing home spending. It just means that it will be taxable when you die. Strangely,
there's a reason you might want that. I know that sounds counter to what we just said, but that's
Yep.
Our next slide.
We have a whole slide devoted to this, but I'll let you know in advance that there are reasons why you might actually want the property to be taxable in your estate when you pass away. And we'll talk about that. Sounds strange, as Annalise said, but it is possible. Second option, if we don't want the property to be includable and taxable in your estate, then we use a long-term lease. So the long-term lease is different because you become a tenant in your property. You do not own anything. You do not retain any ownership interest. You are leasing the property back from the trust, which is basically the landlord. So the trustee of that trust would literally sign a lease as the landlord, and you would sign as a tenant, where you would agree that you have the right to live there for, again, an extended period of time, much longer than a typical lease, so long as you pay rent. It sounds strange that you would want to do that, but again, that serves to allow you to continue to reside there based on the lease terms. It also makes sure that the property is not includable and taxable in your estate. And interestingly, it provides the trustee with the means to pay all of the expenses related to upkeep and management of the property. So if you're paying a rental amount to the landlord, the trustee, they're going to take that money, they're going to deposit it into the trust bank account, and now they're going to have money to pay the taxes, to pay the upkeep, the lawn mowing, the roof, the utilities if necessary, maybe the appliances, whatever needs to be fixed on the property. So even though you're paying rent, there is a purpose for it. We want to make sure that the landlord or the trustee has enough money to take care of the property. And we want you to know that that money really is just going to a different place, but will be used for all of the same things that you would have used it for had you retained it in your name and paid for the expenses related to the property. So just in summary, we'll be deciding throughout the process of doing the trust planning whether it's preferable to use the life estate agreement or the long-term lease. And we'll talk a little bit more about that and explain some of the issues on the tax side for you in the upcoming slides. So I just want to go over with you this potential tax trap for the step up in basis. So this is a little bit complicated, and I'm hesitant to get too far into it because I don't want you to get any more blurry-eyed than you probably already are. But it's just worth, again, knowing that we're watchful on all of these topics as we're doing the planning. And we want you to see that there's a lot going into this decision making and the planning structure that you might not even know or see as we're talking about it or as we're doing it. This particular issue is related to the Pennsylvania inheritance tax versus the capital gains tax. So among other things, there's this confluence of tax-related issues that we're always grappling with and that we're managing for you and making sure are handled the best way possible. But this is a great example of how the decisions that we're making with you and for you can mean thousands or tens of thousands of dollars of difference for your children and beneficiaries. So we'll take an example where we have the value of your home, which is $600,000 today, but you have a tax basis, which is the amount that you purchased the property for, plus any improvements that you made over the years of ownership. Let's say that basis is $100,000. So you might have bought that property a long time ago. We have this happen all the time, where our clients are elderly and they bought a house 50 years ago and they bought it for $25,000 or $50,000 or $75,000, and now it's worth $500,000, $600,000, $700,000. It's fairly common in our area. These property values are skyrocketing. So in that situation, there's a gain of the difference between the value today and the basis, which is $500,000 in this example. So you see here at the bottom, if you pay the PA inheritance tax on $600,000, so that means the house is taxable in its entirety. We have the Pennsylvania inheritance tax versus capital gains tax, and we have a value of the home of $600,000 and the original purchase price plus improvements of $100,000. So we have a gain if we sold that property today of $500,000. If that property is includable and taxable in the decedent's estate, we have a 4.5% tax on the full $600,000. If that happens, there would be a $27,000 Pennsylvania inheritance tax. But look, if we took what seemed like the obvious choice and excluded the house from the estate by putting the assets in the irrevocable trust and having the lease agreement to maintain the ability to reside there, that would mean that we don't get the step up in basis for capital gains. There's a very advantageous federal tax result when you own something at the time you die. There is a step up in basis, which means that your basis goes from the original purchase price and improvements of the $100,000, and it's moved all the way up to $600,000 as of your date of death. So it goes up to the value as of your date of death. So if that happens, then we sell the property and there's no capital gains tax as a result of that occurring. So we pay the $27,000 of inheritance tax, but in return, we pay zero capital gains tax unless the property is sold for more than $600,000. Compare that and contrast it to, what if we exclude the property from the estate? We don't pay the $27,000 of inheritance tax, but now the kids turn around after you pass away and they sell the house for $600,000. They'll have $500,000 of gain at 20% capital gains tax. That's $100,000 of capital gains tax. So we traded in a $27,000 tax for $100,000 of tax. So those are the kinds of things we're watching out for, and we're helping you to manage, and we're deciding with you, do we use a life estate? Do we use the long-term lease? What will the impact of doing one or the other of those things have on your beneficiaries under these different circumstances? So you can see here, this is definitely a potential tax trap, because people naturally think, of course, I don't want this property to be taxable in my estate when I die. Who would want to pay inheritance tax? But you'll see here that paying the inheritance tax is actually better, because we get the step up in basis and get rid of this much higher capital gains tax. So again, this won't be the exact scenario that all of you will be facing. It's just to demonstrate that this is one of the things we're watching out for you.
Thank you, Doug. And sorry, guys, about that brief interruption. I'm glad we're back on track here. We're going to talk about some of these other concerns that clients sometimes raise and what the answers are.
So this is a big question. Sometimes I'll have clients that come to me and it's maybe somewhat tenuous as to the health issues for the person who's considering making the gifts and who are looking to get Medicaid qualification for. So, invariably people will ask, what if what if mom or dad, or what if I or my spouse needs nursing home care before the 5 years is over? The reality is it's okay. In most cases, we won't be perfect, but we'll be fine. Okay. So let's take a scenario where we make this gift of $600,000 to the Medicaid Asset Protection Trust today, or we'll call it January 1 of 24. And unexpectedly, 4 years down the road, on January 1 of 2028, there's a need for the move to a care facility. A stroke or some other illness or health decline has resulted in the need for long-term care before the 5 years is over. So now we have gotten through 4 years of ineligibility period, right? So we have a 5-year waiting period. We have 4 years down. That means we have 1 year left on our 5-year waiting period. So all we have to do is privately pay for 1 year. And then once we're done privately paying for that 1 year, assuming that there are no other ineligibility causing assets, so basically that the person who's applying for Medicaid doesn't have any other money still in their personal name, we can then qualify for Medicaid for that individual, and whatever is still in the Medicaid Asset Protection Trust will be protected, and no further expenditures have to be made from that trust. Okay, so just to further expound on that example, if that person who has moved to the care facility has, let's say, some money left in their bank account, they'll spend that money, okay, first. They're obviously still getting some income, maybe Social Security, maybe pension, that will help defray the cost of that monthly care for that remaining 1 year period. But let's say they've exhausted all of their savings that was in their individual name, and there's need for some money back. Maybe they could need it from the trust. We'll talk about how they can get money back from the trust. So you'll see here on this slide, when those kinds of expenses come up, that the person who created the trust no longer has the financial wherewithal to take care of for themselves, they can call on the trustee to provide them money from the trust. Now, the trust itself will say that the trustee is forbidden to make distributions directly to the grantor or to pay things on behalf of the grantor. That being said, our expectation from the beginning is that if the grantor ever needs money back from the trust, including to get through the remaining period of this 5-year ineligibility period stretch that we have before Medicaid qualification can take place, the trustee can make distributions out to any one or more of the children or other beneficiaries who are listed in the trust document. So classic scenario, child number 1 is trustee and also an eligible beneficiary of the trust. There would be, let's say, 2 other children who would also be eligible beneficiaries of the trust as well. Keep in mind, we talked about this long time ago in the beginning, that we would also have something that we call a distribution trustee. And that distribution trustee is there just to say that it's okay or not okay to take the money out. And we expect them to more or less sign off on the distribution. So in this scenario, mom or dad needs $50,000 to get through the remainder of their 1 year ineligibility period, remainder of the 5-year ineligibility period, which happens to be 1 year in this example that we're giving. There would be a distribution out of the trust to one of the children who would deposit the money into their personal bank account, and then they would turn around and write the check to pay for mom or dad's care in the care facility for the remaining balance of that 5-year ineligibility period. So they would pay $12,000 a month, $12,000 a month, $12,000 a month, whatever the number is that they have to make up for until we're through our 5-year ineligibility period. And then again, once we're through the ineligibility period, the child can stop those payments and Medicaid will presumably pick up and start to pay for the grantor's care in the care facility. Now, that's the example for getting us through the 5-year ineligibility period. There could be other reasons why the grantor might want or need money back from the trust. And among those might be that they're living a long and productive life. And maybe, again, they've spent through their own personal savings and they just need regular old spending money to be returned from the trust so that they can have the money to do the things that they want to do on a regular basis. The same steps, the same process would take place. They'd go to their child and say, you know what, my bank account's down to $10,000, $5,000, $100,000, whatever the number is that you feel comfortable that you want to meet as a threshold. And you could go to them and say, you know, I'd like to get a little bit more money into my account. And we would just follow those same steps. Child trustee makes distribution to sibling, beneficiary. Beneficiary deposits money into personal account, and then out of personal account, writes check back to mom or dad. Now, the trust, as I said, prohibits the distribution directly to mom or dad. But once the money is given out to the beneficiaries and they put the money in their personal account, that's up to the individual person to do whatever they choose to do with that money. And we know that the expectation is that they're going to give that money back to mom or dad. But from a legal perspective, there's nothing that's requiring them to do that. So that's how it works. That's how we make it work that way.
All right. Quick time check. We have 7 minutes left.
7 minutes.
7 minutes.
Wow.
So
time flies when you're having fun.
It sure does. So we'll talk quickly just about, this is something that comes up frequently that clients have questions about. Home needs to be sold, new home purchased, etc. You are able to do that inside of this type of a trust.
Yes. Yeah. This is a common question. So you've transferred your home to the trust and you decide you don't want to live there anymore and you want to move to a condo, downsize, you want to buy a new place, you want to rent a new place, no problem. Trustee is in charge of the house. They can sell the house just like you ordinarily would yourself, hire a real estate agent, go through the listing process, go to closing, sign the paperwork, get the check at closing, deposit the money into the checking account of the trust. And then from there, they can manage the money, buy stocks, bonds, mutual funds, stick it in cash. They could go out and buy a new property for you. They can pay, help pay rent if that's necessary. They can do all kinds of things with the money, just like you would be able to do. So the short answer is no problem. If you need to sell it during the period of time that the assets are held in the trust, that's perfectly fine. The trustee is just stepping into your shoes to take care of those things.
Right. So this is our last batch here. So who, how, and what if? We'll be able to cruise through these pretty quickly, I think, so that we can end on time, which is now in 6 minutes. So who should do this planning? Who is kind of that perfect profile of a person that this makes the most sense for, or couple?
Yeah. So just pure age. I'd say people who are later in life. Most of our clients who are doing this are in their late 60s to late 80s. So that's like a 20-year stretch with probably the middle ages, and within that 20 years being the primary number. So maybe mid 70s to mid 80s are the kind of the most likely individuals who are really thinking about doing this planning in advance. And again, We want people to do this ahead of time, where we're have a clear expectation that we're going to get through the 5 years. The sooner you do it, the better. But we understand that people aren't comfortable at all times to give up ownership and control. So that sweet spot of 75 to 85 really seems where people are falling as far as the majority are concerned on the age scale. From an asset scale, I'd say, and this is somewhat arbitrary, it's certainly not written into stone, but most of our clients are in that $500,000 to $2.5 million range. If they're under that, they probably have assets that they need for their everyday regular care and expenditures, and they're not really focused on saving that smaller amount. But you can do it with those lesser amounts. Certainly not wrong, just kind of telling you where the sweet spot of individuals who are doing this planning falls. And anything over 2.5 million, frankly, they're getting closer to the point where they're able to self-insure, where they have enough assets where they can kind of fend off this higher expenditure of assets, and they're producing more income with the investment of the assets they have. And also, the reality is people with more money are less likely to feel comfortable giving all of it away. I don't know, psychologically where people fall as it relates to that, but people with $3, $5, $10 million, they just have accumulated those assets, and they've built up an estate that's sufficient not only to fend off those long-term care expenses, but now they have assets they're controlling and investing and managing for themselves. And that's where they usually like to keep the assets.
All right, the how much does this planning cost?
So we do this planning with quite a bit of frequency for clients. And when we're doing that planning, we'll do it on a flat fee basis. And typically we see the fees falling somewhere in the $8,000 to $12,000 range. And that will cover everything that we talked about today: selection of trustees, creation of the document, talking through what assets should be transferred, taking care of transferring real estate to the trust, walking through the steps for what a trustee needs to do to move assets to the trust, naming the trust protector, the trustees, and everything else, the tax planning related to the capital gains, the Pennsylvania inheritance tax. So you can see there's so much involved, but just to give you a good faith estimate so that you know in advance what you're looking at, 8,000 to 12,000 is a pretty good ballpark for where you're going to fall. And I'd say the most common is somewhere in that $10,000 range for doing everything that we've talked about on the planning side related to qualification for Medicaid and doing the Medicaid asset protection trust planning.
Okay, so I'm going to cruise through this one. We have about 1 minute left, so I want to be mindful of everyone's time and make sure that we do end on time. What if you didn't do any pre-planning, didn't do anything in advance? There are options for what we call crisis planning. It's not ideal. It's not what we hope clients end up doing, but there is kind of this emergency planning that can be done. You can typically preserve about 40 to 50% of someone's assets, but always the preference is to do the planning in advance so you can be a lot more deliberate and thoughtful about it and preserve a lot more if you do.
We just want you to know on that crisis topic, we just want you to know that if you haven't done planning, and we know that there are people who are procrastinators, and we also know life happens and things can come upon you unexpectedly. And we also know that there are people out there who are children with parents who might be in these different situations, and their parents may not have gotten around to doing this planning, and they may be foisted into positions of authority as powers of attorney, and they may have responsibilities to do things to help preserve their parents' money. So we just want you to know that if it seems like all is lost and someone has been rushed to the nursing care facility and no planning has been done, you can still call us and let us know that this has happened, and we can walk through the steps for the crisis planning at that point in time. While that is not a recommended backdrop and backstop for you, we still, of course, endorse pre-planning, but we still know that this stuff happens. So still call us, because we can help you to at least preserve, in this case, maybe 50% of the assets. So if that happens and you can suddenly save 50% of the remaining assets, you'll be delighted when compared to losing all of the remaining assets.
Okay, thank you, Doug. We don't have a lot of time for questions and answers, none actually. We are past our